Welcome to everybody. My name is Kevin Ruther. I'm the Deputy Director and Chief Legal Officer of the Minnesota Center for Environmental Advocacy, MCEA. Thanks for joining us today for this free CLE that we're doing on environmental justice and Title VI of the Civil Rights Act. I'm really excited to hear what our panelists have to say. If you are new to MCEA, we are a statewide nonprofit advocacy organization. Our mission is to protect the natural habitat, the natural resources of Minnesota, as well as the health of its people using law and science. This presentation today is the first in a series that we're doing, which we call the Green Beagle. And I just want to tell you before we jump in about two other sessions that we're going to have in this series. The first is on August 16th. It's going to be in the same format, a webinar at noon. And we're going to be looking at mining in Minnesota and the need at the same time to transition to a green economy and how those are related and not. And then in the fall, in November, on November 3rd, we're going to do a half-day symposium on the Clean Water Act. As many of you maybe know, the Clean Water Act was enacted in 1972. That means it's turning 50 this year, and we want to both celebrate the act and look at how we're doing with clean water in Minnesota. So you can register for both of those seminars on our website, mncenter.org. But we really are happy that you're here today for this session on environmental justice. I want to introduce the panelists and then turn it over to our moderator. So first we have Stephanie Fitzgerald. Stephanie joined us a couple of years ago. She's a staff attorney. Michael Damasco is here. He is our current legal fellow, came all the way from California to join us as our legal fellow this year. Next we have Eric Iney. Eric is our newest staff member. He just joined us a few weeks ago and is our, Chief Equity and Partnership Officer. So welcome, Eric, and we're excited to hear what you have to say about this topic. And then last is Evan. Evan Mulholland is one of our senior staff attorneys. He's also the director of our Healthy Communities program. So I'm going to turn it over to you, Evan, to moderate. Thank you all again for being here today.
Thank you, Kevin, for the introduction. So I want to open this webinar by naming that the environmental justice movement has a long history that stretches back decades, and it includes sustained struggles against power, the power to locate environmental hazards in Black and Brown communities, and the power that ensures that the richer and whiter a community is, the less likely it will have to deal with high pollution levels. MCEA is committed to working in partnership with communities in Minnesota that have been and continue to be harmed by this environmental racism. Today, we'll be looking at one tool that can be used to make progress towards environmental justice, Title VI of the Civil Rights Act of 1964. I'm going to start the PowerPoint. All right, here we go. So what we're going to cover today is, first we'll go over the text and operation of Title VI, and EPA's implementing regulations, how to file a complaint, and how EPA responds when complaints are filed. And then we will discuss several case studies that show how Title VI has been used in the fight for environmental justice. And then finally, we'll discuss some recent activity by the Biden administration under Title VI and some related authorities. And we'll be sure to leave some time for your questions at the end. So to begin, I'm going to ask Michael some questions. Michael, what is Title VI and what does it do?
Thank you, Evan. So what does it do? Title VI bars discrimination by any agency or program that receives federal funding. This prohibition covers both disparate treatment, also known as intentional discrimination, and disparate impact discrimination. You can see the text of the law right here on the PowerPoint. And next slide. So federal agencies, including EPA, have promulgated rules under Section 602 of the Act. They may not conduct activities that have a disparate impact on the basis of race, color, or national origin. You can see EPA's rule on the slide right here.
So Michael, let's take a step back. Can you give us a bit of a background on Title VI and the Civil Rights Act of 1964 in general?
Yeah, of course. So the Civil Rights Act of 1964 banned segregation and discrimination in public spaces such as schools, parks, and buses, and also in employment. This piece of legislation effectively ended Jim Crow laws, but this legislation came about partially in response to brutal suppression of nonviolent demonstrators in Birmingham, Alabama, and across the South, organized by Martin Luther King Jr. Then President Kennedy reacted by proposing the most comprehensive civil rights legislation in June of 1963. That proposal culminated in the Civil Rights Act of 1964, passed under President Lyndon B. Johnson. So the Civil Rights Act of 1964 was described by Martin Luther King Jr. as the second emancipation. But why are we talking specifically about Title VI? Well, by holding hostage federal funding, it gave the Civil Rights Act more teeth. It particularly helped with the process of desegregating schools.
Thank you, Michael. So when we talk about discrimination, you mentioned two different types. One, disparate treatment, and two, disparate impact. What's the difference between a complaint of intentional discrimination, disparate treatment, and a complaint of disparate impact or disparate effect under Title VI?
Yeah, so the difference is that disparate treatment is intentional, and the action is done specifically because of one's race, color, or national origin. Meanwhile, disparate impact is an action or policy that on its face, it's neutral, but still has a discriminatory effect on the basis of race, color, or national origin. Now, a claim of intentional discrimination or disparate treatment is the more straightforward of the two. To show disparate treatment, one must show that, one, the decision maker was aware of the race, color, or national origin of the person affected by the decision, and two, they must show evidence that the action was taken because of, not merely in spite of, its adverse effect upon the individual. And I think it's also worth mentioning that bad faith, ill will, or evil motive is not a requirement to show disparate treatment. Meanwhile, a claim of disparate impact is based on an action or decision that is, again, it's neutral in its face, but still has a discriminatory effect. Intent to discriminate here is not relevant. To show a disparate impact, you must show three things. First, does the adverse effects of the policy or practice disproportionately affect members of a group identified by race, color, or national origin? To make this showing, the prima facie showing, you must do four things. First, identify a specific policy or practice at issue. Two, establish adversity or harm. Three, establish disparity. And four, establish causation. So that's just the first part. Once that is done, you go on to the second part, which is the burden then shifts to the recipient of the federal funds to establish that they had a substantial legitimate justification for the alleged discriminatory policy or practice. Now, once they show that they did have a substantial legitimate interest, the court must still analyze whether there are less discriminatory alternatives that meet the recipient's legitimate needs, but will do so without the same level of disparate effect. And if there are less discriminatory alternatives, then the recipient must adopt those alternatives. And I also just want to emphasize that it's important to remember that a permit or action can be technically legal under an agency's regulations, but still violate Title VI. Title VI requires its own separate analysis.
Thank you for running us through that, Michael. So to enforcement, is there a private right of action to enforce this disparate impact section of Title VI?
Yeah, good question. First, I want to clarify that a private right of action is when a regular person, a private citizen, is legally entitled to enforce their rights under a given statute. And to answer your question, no, there is no private right of action. In a 2001 U.S. Supreme Court case, the court ruled that there is no private right of action to enforce disparate impact regulations promulgated under Title VI of the Civil Rights Act of 1964.
And that case is here on the slide, right, Michael? Alexander
yes, yeah, that's Alexander v. Sandoval.
So tell us then, a disparate impact claim cannot be enforced by a person directly. So how is this aspect of Title VI enforced?
Yeah, so while an individual may not be able to enforce the disparate impact regulations in court, the DOJ and EPA can still enforce the law. Alternatively, recipient agencies can take action in response to complaints filed by individuals, pointing out this type of disparate impact.
So thank you, Michael. So in other words, an individual or a group of individuals can file complaints with these federal agencies who can then take some action to enforce Title VI, to remedy the discrimination.
Correct.
Thank you, Michael. So we're going to turn over to Stephanie for the, no problem, good work. We're going to turn over to the next part to Stephanie Fitzgerald, who's going to talk about these complaints and what the process is once the process for filing a complaint under Title VI. Stephanie, who can file a complaint under Title VI?
So unlike the rules establishing legal standing for a court case, you don't actually have to be the person harmed to file a Title VI complaint. Anyone who believes that an entity that receives financial assistance from EPA or the agency at issue has violated Title VI can file the complaint on behalf of the people who are actually harmed. And complaints are typically going to name at least one individual rather than just a broad class of people who are harmed.
Thanks, Stephanie. Is there a statute of limitations or another type of time bar for complaints filed with EPA or other federal agencies?
Yes, there is. You have to file a complaint within 180 days of the violation that you're complaining about, but that timeline isn't really always going to be relevant, like in the case of ongoing violations. For example, if you're saying that a particular policy that an agency has is the Title VI violation, that would be a continuing violation, such that the 180-day timeline isn't relevant as long as that policy is still standing.
So what are the guidelines for filing a complaint? Is there a specific format that the complaint has to be submitted in?
Well, the complaint has to be in writing, and you should try to include as much detail as possible. But you have to include your name and contact information, the name of the entity that you're complaining about, the entity that receives the financial assistance, and the alleged discriminatory behavior. That information helps EPA determine whether it has jurisdiction over your complaint.
Got it. All right. So focusing on complaints to EPA of disparate impact under Title VI, what does EPA do when it receives a complaint? And is there a specific part or division of EPA that handles these complaints?
Yes, so EPA has a recently established office called the External Civil Rights Compliance Office, and they enforce a handful of laws, including Title VI of the Civil Rights Act. And ultimately, that office is responsible for investigating the complaints and initiating resolutions. EPA has a case resolution manual that was updated in 2021 that is a pretty detailed guide about how the agency is supposed to step-by-step handle complaints.
All right, so if you're an organization that files a complaint with EPA, what happens at EPA and how do you know what's going on?
Sure. So to get kind of a good idea of how this process goes, EPA actually has a current repository of the complaints from the last 8 years, and it says what their status is. And you'll see there that a lot of the complaints are pending. That's the first status where a complaint starts out. And a lot of complaints sit there for years. So that's the stage where EPA figures out, does it have jurisdiction over your complaint? Did you include all the elements you need to include in your complaint? And there isn't a timeline there. They can let it sit for quite a long time. So second, your complaint can be accepted by EPA, and that means EPA has decided, yes, we have jurisdiction over this complaint, and the elements are met here, but it doesn't mean they've actually made a finding of discrimination. This is just the precursor saying, yes, we'll look into this. And once it's accepted, then the timeline starts running for EPA. They have 180 days to either issue preliminary findings on your complaint or at least starting some sort of resolution process. And third, your complaint can be rejected. A complaint may be rejected because you didn't meet the elements that Michael described above, or because EPA doesn't think that your allegation is sufficiently grounded in fact. It doesn't always mean the end of the road. Sometimes you just need to fix your complaint and resubmit it.
Thank you, Stephanie. And I understand there's quite a few complaints that have been filed over the past few years. And I think we have a link to that list that we can put in the chat, or you can email us afterwards if we can't find it right now. But it's a sort of regularly updated list of all of the complaints over the past few years and what their status is. Many of them are still pending, as Stephanie described.
That's right. Yeah, over the past few years, there's been a sizable backlog of complaints. During 2017 to 2019, the Trump administration did actually clear out a lot of the complaints, but they mostly did that by rejecting them. And in 2020, the Office of Inspector General actually produced a report about EPA and Title VI. And it highlighted that EPA isn't really doing any proactive compliance review. They're waiting until they get complaints before looking into whether their funding recipients are complying with Title VI. So as of 2021, the Civil Rights Compliance Office plans to start looking at compliance more proactively. We don't really know exactly what that is going to look like yet.
Thanks, Stephanie. So once a complaint is filed and it goes through this process and EPA finds that it does have jurisdiction and there is potentially some sort of violation of Title VI, what types of remedies could there be? Is there a chance of negotiated settlement or some sort of schedule of compliance? Like what possible outcomes are there?
Yeah, that's a really good question. And the answer is that it's pretty broad. When the Civil Rights Compliance Office accepts a complaint, the first step they're supposed to do is try to resolve the issue informally through a resolution agreement or alternative dispute resolution. The complainants, the people complaining, can be involved in those agreement proceedings. EPA and the funding recipient often enter into voluntary compliance negotiations. And in reality, the recipient has to totally fail to comply with setting up some sort of compliance schedule before EPA can then move on to, say, take away their funding or refer the matter to the Department of Justice. Typically, advocates are looking for some sort of solution, not to take away the recipient's funding. One really interesting Title VI example comes from the Department of Transportation rather than from the EPA, but it is an environmental justice issue. And that's the case of the Hillcrest neighborhood in Corpus Christi, Texas, which is a majority Black and Hispanic neighborhood in Texas that's surrounded by really intense pollution sources like oil refineries. At the time that the complaint was made there, Hillcrest was 58.3% Hispanic and 34.3% Black, which is 8 times higher than Corpus Christi's overall Black population. So there, the Texas Department of Transportation wanted to rebuild this bridge that was near the neighborhood. And they picked a new route that would essentially cut off the already polluted neighborhood from the rest of the area, really making this residential area like an island of pollution. And residents complained with the federal U.S. Department of Transportation that gives funding to the Texas Department, saying this is a Title VI violation. And the Department of Transportation made a finding that, yes, choosing this route violated Title VI. So the federal transportation department and the state department enter into this voluntary resolution agreement. And what they come up with is that the Texas department had to establish a relocation plan, a voluntary relocation plan that offers to buy out residents from their houses. And by the end of that program, 302 homeowners in that neighborhood had relocated and effectively increased their wealth because Texas had to give the residents enough money to buy a comparable house in a different neighborhood where property values are higher. So that's just one example of what a resolution agreement might look like resulting from a Title VI complaint.
Stephanie, I just want to double back here a little bit. I mean, this is one of the few examples that we have really at all of a federal agency, the United States Department of Transportation, looking at what a state agency did with federal funding. And even though these alternatives that the state chose for the location of the bridge through Corpus Christi or over this neighborhood of Corpus Christi, and none of them were, and to an extent, it was up to the discretion of the state where the bridge was going to go. And the federal government determined that the choice the state made of putting the bridge, cutting off this disadvantaged and majority Black neighborhood, violated Title VI, that it violated federal law. That's what happened here, right?
Yeah, that's right. And, Texas was able to put up a defense there that said, that we have really good reason for doing this, but they weren't able to say there wasn't a better alternative. So that's how this came about.
A less discriminatory alternative.
That's right.
Yeah.
That's right.
Yeah, this is really a remarkable case. It's one of the few examples that we have of, environmental justice being taken seriously and enforced. So let's move on to one more that we want to go over in this. And I do see there are questions. We're going to get to those questions at the end. We're going to go back to Michael. Michael, can you tell us about Genesee County, Michigan, which is right outside of Flint, or Flint is right in that county, and why this case is important for Title VI?
Yeah, of course. So Genesee County saw the proposed construction of a power station in a predominantly low-income African-American community. Concerns were over the potential emissions of lead, mercury, and arsenic from the plant.
Michael, I'm just going to interrupt 1 second. When was this first proposed? How far back are we talking? Sorry.
Yes, this was proposed way back in 1992.
Okay, go ahead.
And here you can see an overhead view of the plant that was eventually constructed. And next slide.
Yes, there we go.
Yeah, and here you can see a timeline of the case as it unfolded. So the case starts all the way back in 1992 when the St. Francis Prayer Center of Flint, Michigan filed a Title VI complaint against the state of Michigan and its Department of Environmental Quality. The complaint alleged disparate treatment and disparate impacts in both the location of the facility and in the process of permitting the facility. So that was 1992, and in 1995, the power station began operation despite this pending Title VI complaint. And it wasn't until 2017 when the EPA made a final finding of discrimination, finding that there was intentional discrimination. So it's quite a lot of time for that to happen. But why did EPA conclude that there was intentional discrimination? Well, that's because the EPA found that African Americans were given fewer opportunities to speak, less time to review documents when compared to non-African American communities. Additionally, the state unnecessarily sent armed security to the only hearing held in a predominantly Black neighborhood in North Flint. Historically, force has been used to intimidate African Americans attempting to exercise their right, and EPA took this into account. But while they found that there was intentional discrimination, EPA found that there was no disparate impact, saying that there had been no harm to public health from this power plant. So what's happened since 2017? Well, EPA did not impose any punishment on the state of Michigan or its permitting agency, but they did make a number of suggestions that they expected the agency to take, such as improving their public participation program, developing and implementing a foundational non-discrimination program that establishes appropriate safeguards, and ensuring that they have an appropriate process for addressing environmental complaints.
Thank you, Michael. This is really a remarkable timeline. A complaint filed in 1992 and then a finding in 2017. Why is this case important for us studying Title VI and moving forward with advocacy on Title VI?
Yeah, it's actually a really important case because it is EPA's first and only final finding of discrimination. It hasn't happened since. So I think looking at this case, it illustrates both the viability of using Title VI. There was positive outcomes of this, but it also really illustrates the shortcomings and opportunities for improvements regarding Title VI. It shouldn't have taken 25 years for this to be addressed. And additionally, I think it's also really important because it serves as an example. It's an important precedent that people or groups can look to when developing their own Title VI complaints.
And we can share, I think we may have the links to some of the documents about this case.
Yes.
I'm going to move to Stephanie to talk about another case that's been in the news lately, and that's Lowndes County, Alabama. What is the situation in Lowndes County?
Yeah, thanks, Evan. So Lowndes County, Alabama is a county between Selma, and Montgomery in South Central Alabama, and it's made up of a majority of Black residents. More than 80% of the residents do not have access to a municipal sewer system. And so the option when you don't have municipal sewer is to install your own septic system to dispose of household wastewater. But there are a couple of factors in this county that make that really tough. So Lowndes County is in the Black Belt of Alabama, which refers to the type of soil there. You can see the pink strip kind of through the middle of the state. And this is a map of the soil types in Alabama. And that pink strip is Blackland prairie soil. And that's a type of soil that makes it harder to install septic systems, more expensive, and it means they fail more often. So it could cost up to $30,000 to install a septic system at your house in this area. And then compounding that issue is that this is a low-income county. And so you have a really expensive, option to install a septic system where a lot of the residents don't have municipal sewer. So in 2011, the Alabama Department of Public Health itself estimated that somewhere between 40% and 90% of residences in their county didn't have a septic system or an adequate one. And that 50% of homes with working septic systems, those systems were expected to fail or were already failing. So it's a really bad sewage situation, and it led to a hookworm outbreak in the county.
So Stephanie, can you tie this to Title VI? Well, how did the community tie this to Title VI? What was their complaint?
Yeah, so Earth Justice filed a complaint with the U.S. Department of Health and Human Services on behalf of a group there in Alabama called the Center for Rural Enterprise and Environmental Justice. And so they alleged that the Alabama Health Department, which receives funds from the U.S. Department of Health and Human Services, they alleged that the Alabama Department violated Title VI by failing to address the sanitation issues or the hookworm outbreak, because both were having a disparate impact on the Black residents of Lowndes County. Access to functional, affordable on-site sewage systems was disproportionately lacking for Black residents compared to the white residents in the county. And the part of the county where more white people lived is actually, was actually connected to the municipal sewer system. So they weren't facing this choice of really expensive septic system that doesn't work very well. So where this is at right now is that the Department of Justice has decided to open an investigation in response to the complaint. And it's the Department of Justice's first environmental justice investigation.
Stephanie, this sounds really momentous for Department of Justice. Why is this important? Can you talk a little bit more about why this is important precedent for the country and for our efforts as a movement for environmental justice?
Yeah, well, it's really important because first, as Michael explained, individual citizens can't enforce disparate impact claims under Title VI. So we can file complaints, but we're relying on the Department of Justice or the federal agency to actually take the complaint seriously. And this is an indication from the Biden administration that it's taking its goal of addressing environmental justice seriously. The administration has made announcements and set priorities, and now it's taking action. So in the Lowndes County example, this is a community that has relatively little political power or access to government officials. And the Alabama Health Department clearly has been aware of the situation for a long time based on statements they made 11 years ago. So this is a change of pace for the federal government to actually step in and do something about it.
Stephanie, thank you for summarizing this awful situation in Lowndes County. We're going to turn now to Eric Inney, who is our Director of Equity and Partnerships. And first, I want to welcome Eric to MCEA. We're very fortunate to have you as the newest member of our team. And I'm going to ask Eric to talk a little bit about the coalition he was a part of in Michigan, opposing a proposed asphalt plant named a company called Ajax that was proposed near Flint, Michigan. Eric, can you tell us a little bit about this proposal and what the communities nearby were concerned with and why they were opposed? I'm going to switch the slide here. There we go.
Yeah, thank you very much. Thank you very much, Evan. And this is a very important case, and it really shows why Title VI is important as a tool because the Ajax plan is located in Genesee Township, which is nearly 90% white, and almost all of its elected leaders are white. Yet those living within 1 mile of the Ajax plan are predominantly communities of color. Residents living close to the industry, to the industrial area are 77% Black and 10% Hispanic. So also Genesee Township has historically permitted polluting industries where communities of color live and where federally assisted low-income housing is sited. The Ajax asphalt plant, which will emit many air contaminants, including lead, will be sited less than 1,600 feet from public housing in a low-income Black neighborhood that is already overwhelmed by high levels of air toxins and particulate matter from industrial activity. So it only makes sense that it's also good to know that none of the predominantly white township of the zoning map of Genesee Township are zoned for heavy industries. So you now see why Title VI complaint was eminent in this case. And as has been said before by my colleagues, Title VI is one of the tools available to communities who believe that race was a factor in the permitting process. So in the case of Ajax, grassroots organizations in Flint and around the state of Michigan formed a coalition known as the Coalition to Stop the Ajax Asphalt Plant, tried to stop Eagle from granting this air quality permit to Ajax on several grounds, including the fact that the permit is located in a predominantly Black neighborhood, already overburdened by air quality issues. So the coalition did a lot of things. The coalition brought this to the attention of the EPA, where a letter was sent to Eagle, EPA sent a letter to Eagle recommending that a cumulative impact assessment is done, or an alternative site is used for the project. But Eagle rejected all of these recommendations from the EPA and went ahead and granted a permit. So
Eric, can I just interrupt? Can you inform everyone who may not be aware what EGLE is? EGLE.
Yeah, EGLE is the Michigan version of Michigan Environmental Protection Agency. So it's Michigan Department of the Environment, Great Lakes, and Energy. So it's called EGLE.
Okay, thank you.
So the coalition brought this to the attention of the EPA, and the EPA sent a letter, and EGLE ignored all the recommendations that the EPA proposed. So the coalition had no other option after the permit was granted to Ajax by using this other tool, which is a Title VI complaint. The coalition filed a request for review, also known as Title VI complaint. The EPA granted a request. The review process is now in progress, and we are waiting to see the outcome of the review. I think Title VI as a tool will only be effective if Title VI really impact communities, because if it doesn't correct the injustices that communities are complaining about and which it is intended to correct, then the tool will become useless. So for it to be really effective, the enforcement of Title VI is very important to give communities trust in the system by holding federal agencies accountable.
Eric, I want to interrupt our flow here for a second. Is that you in the picture right there on the PowerPoint?
Yeah, that's me. That's in front of the St. Francis Prayer Center. You can just see the asphalt plant, Ajax asphalt plant from where I was standing.
Excellent. Well, thank you for your overview of what's going on there. And I appreciate the description of the situation and the sort of the hope of Title VI and the difficulty of the historical failure to enforce by EPA and the hope that we have that EPA is starting to do this.
Yeah, and I like that you pointed out that it's, the tool isn't much of a tool if it's not actually effective for communities who want to use it. I think that's a really good point. Evan, I wanted to ask you if you could tell us a little bit about what's happening now. What is the Biden administration doing to address environmental justice and the disparate impacts we are still seeing?
Sure. Yeah, thanks, Stephanie. So, I mean, we've talked about this a little bit, but the Biden administration is making noises about environmental justice a lot. They are talking about it and taking it seriously, as we saw with Department of Justice's announcement about Lowndes County in Alabama. EPA's draft 2022 to 26 strategic plan set as a new top-level goal. Number 2 of their 6 top-level goals is to, quote, take decisive action to advance environmental justice and civil rights. This goal was not in their plan the last time around. So one way EPA plans to do this is to ramp up proactive civil rights compliance reviews in overburdened and underserved communities. And Stephanie mentioned this earlier in the presentation, but we're not sure yet how this will be done. I mean, there's thousands and thousands of permitting and other decisions that are made by federally funded programs. And it's unclear how EPA is going to be figuring out which are the ones to look at before complaints are even filed. We'll see. Second, President Biden's Justice 40 initiative is very important. It was announced in his climate crisis executive order number 14008 from 2021. The Justice 40 initiative is intended to ensure that 40% of the benefits of certain federal funds, including clean energy funding and clean transit funding, go to disadvantaged and overburdened communities. And earlier this year, both the Departments of Justice and Health and Human Services established new offices of environmental justice that did not exist before, that are designed to address health disparities and hold polluters accountable. And specifically, Department of Justice has released an environmental justice enforcement strategy that emphasizes a focus on these same overburdened and underserved communities, both in enforcement, as in where to apply DOJ resources, and also in public engagement so that people know what the department is doing and how they're doing it.
Thanks. Could you also tell us if there's anything going on in Congress with respect to Title VI?
Yeah, this one's really exciting when I learned about it. There's a bill that would essentially create a private right of action for disparate impact discrimination claims under Title VI. This would reverse that decision in Sandoval that Michael discussed earlier. The Environmental Justice for All Act was introduced last year, March 2021, by House and Senate Democrats, including our representatives Ilhan Omar and Betty McCollum. Yeah, this bill would, among other things, it's quite an extensive bill, you guys should look at it, but it would amend Title VI to clarify that Section 601, the first section, includes both intentional acts of discrimination, disparate treatment, and actions that have a disparate impact. And it adds specifically a private right of action to allow citizens and citizens groups to go to court to enforce Title VI. And like I said, essentially overturning the Sandoval decision. So we are just about at the end of this presentation. I see we have some questions, and we're going to address those in just a second, but I want to thank everyone for coming, and let's just move right into the questions. I'm going to open up the question box, and I'll tell you what, I'll also stop screen sharing so we don't need the PowerPoint anymore. All right, first question. I'll ask them and then we'll decide how to answer them. First question is, are we finding that particular organizations are initiating complaints, or are they more individualized? I'll send this to Stephanie. Is it organizations, or is it more, maybe more localized is a good way of thinking about this question?
Yeah, that's a great question. I can't tell you the full, I haven't reviewed all the Title VI complaints that have been filed, but I've seen a lot of local organizations where like sometimes a bigger organization like Earth Justice or Sierra Club will file the complaint, but it will be on behalf of individual citizens in the area or even a local organization in that area. It looks like Eric agrees with me. Eric, is that your experience too?
Yes, most often these legal organizations are representing community-based organizations, grassroots organizations, and even some smaller groups. So they're just representing most of the time. Yeah,
I think it's really important, just as an environmental justice principle, to make sure that the facts are so location specific and specific to the neighborhoods and communities involved. What's the background level of contamination, air and soil? And then also it's really important to make sure that people are a part of the coalition and a part of the complaint, that their voices are in it. I've seen some complaints where they, quote people who have no particular scientific, formal scientific background, but they have a lot of background in what the effects are from, the ongoing pollution and contamination and what the new thing proposed is. It's an important thing to do.
And Evan, if I can cut in, I think it's made even more important by how we understand the resolution process to go, because there's such a wide variety of how these complaints can be resolved. It seems like it's really important that local community is involved in the process from the start, so that when EPA or whatever federal agency starts figuring out what the resolution is going to look like, it's something that people want. It's the resolution that people are seeking.
Yeah, I mean, one of the ultimate remedies here is for the federal agencies to pull funding, to say that you're continually discriminating and we're going to not fund you anymore. But that's not really a good outcome. What we need are stronger, fairer, more just local and state agencies. So that's why the alternative dispute resolution and the negotiated settlements are so important. All right, next question. How small a group can a Title VI complaint be filed on behalf of? Can a complaint be about a city's policies which affect a particular neighborhood? Could a city violate Title VI? I'm going to send this to Michael.
Yeah, there's no threshold you need to pass for how big the group needs to be, so that's fine. And about the city's policies, of course, city, as long as they receive funding from the federal government and they meet all the elements to establish a Title VI complaint, then you can definitely file a complaint against the city. And we actually saw this with the Genesee County as well. It was filed against the city and the, it's filed against the state and the Department of Environmental Quality in that state. So I apologize for that mistake, but yes, you can file it against the city.
Yeah, that sounds right. As long as there's some federal funding, then the city is subject to Title VI.
Yeah, which wouldn't be hard to establish.
Right. Let's see, we have a couple more questions here. I'm just looking at them. Have we explored the intersection of implementation of treaties with sovereign tribal nations and the provisions of Title VI, specifically as a prerequisite for economic development? I think part of this question is could there be a Title VI violation as a result of a permitting action or other state action that disproportionately or disparately impacts people who are members of a tribe? Well, I believe that the answer is yes, that yes, that people in our tribal nations, people who are members of those protected classes, can complain and file a complaint, and there would be a finding of discrimination if you could show that there was a disparate impact that disproportionately harms those protected classes. So yes, a lot of the complaints that we've reviewed, I don't know if we saw any that dealt with tribal nations. but there might be some out there. We haven't reviewed all of them.
Evan, on
go ahead.
the economic impact part of that
Yeah,
question, I saw the precursor to that question just being about, you know, how does a agency like a state or cities, you know, agency saying, well, this is for economic impact, or this is for economic development, it's going to be good for a lot of people. And I think the question that the person is asking there is like, how does that relate to Title VI? And I see that coming, I would assume that that would come in a lot in the funding recipients' explanation of why they chose the path that they chose, and that whole burden shifting framework that Michael was talking about. Like, yes, this has a disparate impact on this community, and then the agency like the Texas Department of Transportation says, yes, but we chose it for this really good economic reason. But they still, you know, the burden shifts back, and they still have to show that there wasn't a less discriminatory alternative. So that's how I think the economic justification might fit into a Title VI complaint.
Yeah, thank you, Stephanie. I'm going to direct the next one to Eric. So the next question is, as I've listened to this presentation, it seems grim in terms of achieving results. The description of backlogs and slowness and little teeth in sanctioning state agencies who are discriminating in effect. Do we view it similarly, and are there ways to push for more and faster justice? So Eric, are we similarly discouraged by this presentation, or do we see it differently, and how can we push for more and faster environmental justice?
Yeah, I think during the presentation, I think Michael showed just one case that was decided in favor of communities. And I think that many communities do not trust the process because, for example, the Ajax case is very clear that the EPA intervened and tried to stop the state agency from granting the permit. And the reasons that the EPA gave, race was one of them, as well as even telling them to do cumulative impact because the community is already overburdened with pollution. So the agency, the state agency, ignored the process. So I think that what needs to be done is for the agency, the federal agency, the EPA and other federal agencies to really get communities to have confidence in the process. And what the Biden administration is trying to do, we are just hoping that they're gonna try to instill that confidence by really holding the state agencies accountable for under Title VI. Because like I said when I was talking, if this is not done, then the tool is useless.
So some optimism, but it remains to be seen if the Biden administration, what they're going to be doing ultimately. I think Eric, I think there's a sense in the country that there's some progress being made. At least there's this sense that we can't just keep doing the same thing and, you know, recreating the same patterns of discrimination and excess harm on people of color that we've been doing forever. Like what we saw in Chicago, where the scrap metal yard and the scrap metal crusher was going to be put in the low-income Black community. And ultimately, at least for now, it's the communities won that. So I think there's some sense that this is getting slightly better in some places. And, you know, watching the Department of Justice and watching the EPA administrator go to Lowndes County in Alabama and say, this is not fair, we're going to do something about that. I mean, that's like the highest people in government, you know, the Attorney General and the administrator of EPA. So I'm hopeful, but there's a lot of momentum and inertia, I think, in the way we've been doing things as a country. All right, one more question here. Have there been any complaints from Minnesota against Minnesota agencies or Minnesota counties? Are there any groups actively looking at this option of Title VI complaint in Minnesota? Well,
So there
go ahead,
aren't any
Stephanie.
pending Minnesota complaints right now, but I don't think that means there aren't situations in Minnesota that would be, you know, ripe for a Title VI complaint.
Yeah, I think if there's, thank you, Stephanie. I think if there's a situation, which I'm almost positive that there are, that a permit is about to be issued or is in contemplation of becoming issued and a new source of pollution that has a disparate impact on environmental justice areas through the EJ screening tool. You know, we've seen through this research and through our look at the complaints that are out there and the complaints that have been founded, that you only need one decision. You know, you only need the one, we saw from the Texas complaint, that's one decision to put the bridge here versus here. And the United States Department of Transportation found that this choice had a disparate impact and that there were alternatives. So there are a lot of situations I think we can all think of in Minnesota and other places where a state agency is making a decision like that, and the impacts are disproportionately borne by protected class, people of color, depending on race, national origin. So I think it's an area that I expect a complaint in Minnesota. I will not be surprised at all if we see a complaint from groups in Minnesota who are working on these issues.
Evan, I think like after our research for this presentation, I think it's something we would look at in future cases too.
Absolutely. It's a tool that can be used. Let's see if there's other questions here. Are there Minnesota state laws that are similar to Title VI? What is the status of enforcement of a disparate impact claim under Minnesota law? Michael or Stephanie, do we have a sense of Minnesota anti-discrimination laws? I think we're focusing on Title VI as a federal law, so I think we'd have to follow up on that one. All right, there's a question in the chat. Let's see, question in the chat. As a layperson, let me just read this through. This is a question about West Virginia versus EPA, and this question, I see it, the Supreme Court decision that we're waiting for on climate change and the ability of EPA to regulate greenhouse gases and how that would intersect with Title VI. And the question is how to increase public awareness of this major shift in EPA's ability to function. Part of our role, I think, as a statewide environmental nonprofit is education, and we are going to be shining a light on this decision that we're expecting. Either way, however it comes out, we're going to be talking about that. So, you know, beyond that, I'm not really sure to the questioner. I think that might be all of the questions. So I think we're just about done. I think we've hit all of the questions. You're welcome. Sorry, it's with the chat and the questions a little bit difficult to see everything, but I'm just going to wrap it up here. I want to thank everyone for coming to this webinar. And I want to remind everyone that one, we're a nonprofit that is supported by you all by donations. And second, that we're having some upcoming CLEs that Kevin Ruther mentioned in the beginning of this. The first one next is August 16th at noon, Mining and the Climate Crisis. And then November 3rd in the afternoon, we're having a half-day symposium on the Clean Water Act. You can sign up on that link in the chat, or you can sign up on our website. And then finally, I just really want to thank, right, for the CLE credit. The CLE has been approved for one elimination of bias CLE. And there's a poll for you to take so that we can learn what we did well and what we need to improve on and how you found the webinar. A little bit of an evaluation afterwards, which is really important for us if you could fill that out. So thank you very much. And thank you, Michael and Stephanie and Eric and the rest of the staff at MCEA who helped put this together. And, I appreciate your attention and your interest in this topic. And please get in touch with me. You can look me up on the web, emulholland@mncenter.org, if you have any questions or want to talk about any of these cases, or you have your own situation that you think is a federal discrimination violation. All right. Thank you very much. Have a good afternoon.
Thank you, everyone.